Hello, Professor Bill Slomanson vagyok. Örülök, hogy itt lehetek Debrecenben. Remélem, érdekes lesz az előadásom. Ha nem baj, angolul folytatnám. The reason I'm presenting it in English is because I don't want to be arrested for slaughtering the Hungarian language. My apologies. I'm still on California time, but it's my hope that I will be the only one who is yawning for the next half hour or so. Thank you so much for inviting me to your university. It's an honor to be presenting in this illustrious university. I previously had the honor of visiting at Miskolc earlier, a few years ago, so I'm very, very pleased to return to Hungary through the good offices of Professor Sándor Széchenyi of Debreceni University. There will be a question and answer session at the end that will not be recorded, and I decided there's a very convenient division of labor. For the easy questions that you have, I will take those. The hard questions will be directed to Sándor. My topic is the Crimean Annexation under international law. My conclusion, which I'll give you up front, is that Crimea is likely to be the epicenter of Cold War II. You have the blueprint for my remarks today, which has been passed around. I will be presenting in 7 parts. The first of 7 parts is the contemporary expansion of Russian influence. We can actually begin, I think, with President Reagan's famous request, Mr. Gorbachev, tear this wall down. Well, that wall did come down, but the US did not keep a promise that you never see in the news. Reagan's Secretary of State said that if the Warsaw Pact were terminated and went away, NATO would not move 1 inch eastward. Well, it did all the way to Russia's borders. The 2002 NATO-Ukraine Action Plan was of great concern to Russia. In 2005, Ukraine was the first Commonwealth of Independent States member to join the NATO Partnership for Peace program. And in 2015, very recently, the Ukrainian president announced that Ukraine would be an EU member by 2020. So Russia has a number of concerns, which include missile defense shields. When President Obama took office in 2008, he scrapped the US-NATO plan, did away with that plan for missile defense shield in Poland and Czechoslovakia. And earlier this year in 2015, the Poland and Baltic states asked NATO if they would focus their resources on a missile defense system against Russia. Just 2 weeks ago, Ukraine announced that it was seeking a missile shield as well. Russia's response was that if the Ukraine obtains that shield, then Russia will place nuclear weapons in Crimea. The contemporary expansion of Russia's influence actually begins a little bit earlier with Georgia's South Ossetia and Abkhazia provinces. As the Soviet Union neared collapse, Georgia revoked the autonomous status of both of the provinces, followed by their subsequent declarations of independence. These dormant separatist conflicts flared up in August of 2008. Russia entered Georgia to launch its operation to protect its Russian citizens. As of 2003, as you probably know, Moscow has been issuing Russian passports to ethnic Russians in non-NATO locations within the former Soviet Socialist republics. Russia has reintroduced its military, or did reintroduce its military into Georgia in 2008, after NATO had announced a plan to bring Georgia and Ukraine into NATO. Russia borders on both of the countries, sharing a 1,400-mile border with Ukraine. And let's not forget how the United States reacted in 1962 when it discovered that there were Russian missiles very close to our shores in Cuba. Georgia's deteriorating relationship with its South Ossetia and Abkhazia provinces was arguably influenced by the Kosovo Declaration of Independence just 6 months earlier in February of 2008. Both the US and Russia loudly proclaimed that South Ossetia, Abkhazia, Kosovo would not be viable precedents for other secessions. Those disclaimers could actually be the subject of another talk, but are beyond the scope of my remarks today. To develop my conclusions, I'm now going to give the world's shortest course on statehood. So we move to part 2 of 7 parts, which is paths to statehood. The UN Charter was not written with secessionist conflicts in mind. Under Article 2.4, members must refrain from using force against the territorial integrity, or the political dependence of other states. The Charter did not contemplate problems like South Ossetia, Abkhazia, Nagorno-Karabakh, Kosovo, Crimea, Transnistria, growing beyond a purely intrastate context, serving as proxy wars on behalf of other member nations. That just wasn't anticipated in 1945 when the Charter was being drafted. Under 2.7 of the Charter, the organization is not allowed to interfere in matters within the domestic jurisdiction of its member states. So both states and international organizations and the dawn of a new era after World War II was over in 1945. Both states and international organizations were expected to honor international borders. Now, the early 1990s witnessed a splintering of statehood in the aftermath of the Cold War, after the Cold War was over. The USSR peacefully dissolved into a number of 15 different independent republics. The former Yugoslavia violently erupted into a half a dozen states. And if today's ubiquitous separatist groups could have their way, the number of states and the size of the international community of nations would significantly increase as those movements pursued their claim rights to secede from the mother states. Familiar movements include the Kurds, the intersection of Iraq, Turkey, and Iran, the Chechens, Tibet, formerly Spain's Basque and Northern Ireland's Irish Republican Army struggles, and most recently ISIS in Iraq and Syria. So, given the centuries, actually, of territorial conflict, there is no multilateral treaty process. And why is that? Or there's no treaty on secession in international law. And why is that? Well, that's because that would be political suicide. States would never attend a conference that would be designed to determine the basis for secession. Would you attend a meeting in your neighborhood, the group objective of which would be to decide which neighbor gets your child, or that your child would be free to decide that he or she is no longer in your family? So, state practice thus spawned three potential paths to statehood. They are succession, secession, and self-determination. Succession, as you know, occurs when one state takes another one over. Since the Crimean annexation this year, Russia has entered into treaties with South Ossetia and Abkhazia, actually in 2014 and 2015, that call for nearly full integration with Russia by way of military and economic incorporation into Russia's growing sphere of influence. On its face, it appears that those treaties are between sovereign nations, but the reality is that I think there's a paper-thin line between their disputed sovereignty and Russian succession. Secession is the second of the three subtopics in this whirlwind overview of the paths to statehood. Today, of course, as you know, there are many separatist movements that are actively pursuing a provincial breakaway from the mother state. In a few moments, I'll move on to unilateral secession, which is the primary focus of today's remarks. But moving on in this quick whirlwind overview of paths to statehood, the third path is self-determination. And self-determination, of course, is not synonymous with statehood. Its undefined contours didn't really blossom until the 1960s, when the United Nations was facilitating the decolonization process in Africa. Self-determination under decolonization was quite distinct from today's and the subsequent misapplication of the term self-determination, which today's separatists use all the time, but inappropriately use as a basis for justifying secession. Self-determination arises in many contexts. Europe's gypsies, for example, have a right to self-determination. Hungary played a very leading role in all of that 2 years ago in aiding self-determination of gypsies, the gypsy minority, when the perpetrators of the serial murders of gypsies were arrested and prosecuted in Debreceni, which is the subject of the famous documentary Judgment in Hungary. Unlike the separative movement du jour, gypsies don't intend to create a gypsy state. Their objective is to freely migrate at will, but not to establish a gypsy nation. Back to South Ossetia and Abkhazia, Russia claimed that it was a mediator in trying to mediate between Georgia and its provinces, that there was a need to introduce a Russian peacekeeping force to stem the flow of ethnic Russian blood at the hands of Georgia. But Russia's border crossing was done in the name of Georgia's alleged denial of self-determination of its ethnic Russians. But the separatists in that area failed to observe the post-decolonization distinction between internal and external self-determination. That is, all peoples of all states enjoy at least the theoretical right to determine their own internal political status. But the inviolability of international borders precludes the extension of self-determination to facilitate any external political change. I now move on to part 3 in my blueprint, which is unilateral secession, a very steep path to legitimacy. Of the 3 pillars of mainstream statehood analysis, the focus of today's presentation is on unilateral secession from a mother state. We'll start with the default rules. International law does not permit secession, but international law doesn't prohibit secession either. But there's a very, very clear bias against secession. And that bias is usually articulated in terms of preserving the territorial integrity of existing nation states. There are a number of international instruments which the people in this room I'm sure have studied, which confirm the inviolability of internationally recognized borders. So remedial secession is an equitable remedy to ameliorate the harshness of the anti-secession bias. And one doesn't have to look far to get evidence of the bias against unilateral secession. In Soviet times, for example, Article 72 of the Soviet Constitution said that only the 15 Soviet Socialist republics had the right to secede from the Soviet Union. That right did not include the political subdivisions. Georgia thus had a constitutional right to secede from the Soviet Union when it did, but not its South Ossetia and Abkhazia oblasts. Upon the demise of the Soviet Union, the European community issued fresh guidelines for recognizing the new states of Eastern Europe. And I quote, "We adopt a common position, a process of recognizing these new states which requires respect for the inviolability of all frontiers, which can only be changed by peaceful means and by common agreement," close quote. So, with South Ossetia and Abkhazia, they became recognized by only a small handful of other nations because of this bias against secession. But let's not assume that the 110 recognitions of Kosovo equates to the validity of its secession. That, too, is a topic which, unfortunately, is beyond the scope of today's remarks. The G8, its response to Russia's intervention in Georgia was unmistakably direct, and I quote, "We, the G8, condemn the action of our fellow G8 member. Russia's recognition, basically, of the independence of South Ossetia and Abkhazia violates the territorial integrity and sovereignty of Georgia, and Russia's decision has been called into question and has very seriously called into question Russia's commitment to peace and security of the Caucasus," close quote. So, a basic tenet of international law is that when there's no multilateral treaty, you can resort to state practice, what states actually do. When state expectations are unclear, because this is a relatively new area, remedial secession, then when state expectations aren't clear, Article 38 of the International Court of Justice statute provides a list of recognized sources. Decision makers can then resort to the decisions of national and international courts for guidance on the content of international law. I'm guessing that in 2010, some of you were waiting for the International Court of Justice to come to the rescue. That is, you envisioned that the World Court would authoritatively articulate the ground rules for secession. Instead, the Kosovo independence case dodged the perfect opportunity to bring clarity to the customary international law of remedial secession. Serbia had convinced the UN General Assembly to seek an advisory opinion regarding the legitimacy of the Kosovo Assembly's 2008 unilateral declaration of independence. Kosovo's lawyers left The Hague claiming victory, but the ICJ was very, very careful not to make any pronouncement about the applicability of remedial secession or the legality of Kosovo's claimed statehood. Those who rely on the analysis of politicians or journalists would likely be surprised to read the key passage in paragraph 51 of the court's Kosovo opinion, and I quote, "The question asks for the court's opinion on whether or not the Declaration of Independence is in accordance with international law. It does not ask about the legal consequences of that Declaration of Independence. In particular, it does not ask whether or not Kosovo has achieved statehood. Accordingly, the court does not consider it necessary to address whether or not the declaration has led to the creation of a legitimate state. Close quote. The ICJ has significant flexibility when it's asked to exercise its advisory jurisdiction. Here, however, the court ducked its opportunity to use its advisory jurisdiction to bring clarity to the concept of remedial secession. So, under Article 38 of the ICJ statute regarding sources of international law, we turn to what is now the leading case in the world involving unilateral secession and the elements required for validity. And that is Canada, the Canadian Supreme Court's 1998 Quebec secession case. Quebec had engaged in a poll or a referendum in 1995, and the referendum was to see whether or not Quebec would secede, or the French part of Canada would secede from Canada. The result of the referendum was 50-50, and basically the referendum was not successful. So in the event that Quebec, that was unsuccessful at the polls, would ultimately decide to secede, the Canadian Supreme Court authoritatively articulated the law of unilateral secession. The court enumerated the extraordinary circumstances that are required to trigger a remedial secession, which is an exception to national sovereignty. And the court's analysis was rooted in three primary elements. First, there must be a distinct people. Second, there must be gross human rights violation. Third, there must be no alternative but secession. So, as to element number one, a people. There's a lot of debate, as those of you who are studying human rights know, about the meaning of the term people. So this element itself presents problems in certain contexts. Nagorno-Karabakh is a classic example. It's a contemporary conflict spawned by a unilateral declaration of independence. 95% of the population of Karabakh is Christian Armenian. It would not be a distinct people if Karabakh is in Armenia. It would be a distinct people, the Karabakh people, if Karabakh was a part of the Muslim nation of Azerbaijan. So, one feature of this debate that's quite interesting is, where is Nagorno-Karabakh? Well, that depends upon who you ask. And there's three answers to this deceptively simple question. Karabakh was assigned to Azerbaijan after World War I. The West's position is that it's still an Azeri province. In 1989, the Armenian SSR declared unification the unification of Karabakh with Armenia. But then 2 years later, for the third answer to the question where it is, Karabakh announced its unilateral declaration of independence. It's been unrecognized by any nation, including Armenia. Once again, I don't have time to discuss this incredibly interesting subtopic, but basically what we come to is, who are the people of Crimea, getting back to the Crimean situation. I think there it's a little bit clearer. That's because during World War II and just after World War II, Stalin perpetrated multiple ethnic cleansing campaigns in Crimea against the Tatars. The ethnic Russians in Crimea are arguably a people in Ukraine today. I don't take any position on the legality of how that occurred. I'm only speaking to the reality on the ground. So you do have in Crimea a Russian people, if you think of Crimea in relation to all of Ukraine. The remedial unilateral secession's second element is gross human rights violations. And remedial unilateral secession has the most appeal for the international community when the majority population or a government of a particular country renders the minority unable to develop its identity within the framework of the existing state. The arguable bases that are often raised to satisfy the human rights claims are humanitarian intervention, the need for it, and claims of genocide. Both of them are often imitated, and they are rarely duplicated. The problem is that international law frowns upon unilateral border crossings in the name of humanitarian intervention. The UN's 2005 Human Rights Initiative, R2P, or Responsibility to Protect, does not envision a humanitarian intervention by one country, but rather it envisions a multilateral process of intervention to take care of human rights problems. Genocide is another common term that we hear. We heard it during the Russia-Georgia war and also in many other contexts. And genocide is very easy to claim, but it's hard to prove, and that's for three reasons. One is the failure to distinguish between ethnic cleansing and genocide. A second is liability for genocide requires the specific intent to eradicate a group or a people as such. And thirdly, there has to be credible witnesses and trustworthy documentation. Regarding the 2008 Georgia-Russia war, both claimed genocide, but neither country was able to gather the requisite evidence to establish genocide. In Crimea, the separatists would have a major problem with this particular element for the validity of unilateral secession, and that's because there was no evidence of attacks or intimidation on the ethnic Russian population of Crimea. While that may have occurred, neither Russia nor the Crimean separatists have sufficient evidence of any genocide occurring in Crimea. All right, so in this whirlwind overview of paths to statehood, we've now covered two of the three elements for a validity of unilateral secession, that is a people and gross human rights violations. Now we move on to the third element, which is actually probably the most difficult to prove, and that is that there has to be no alternative but secession. And that's because of the bias against unilateral secession because of the inviolability of borders. This element is hard to prove or isn't often successful. There are many multiple endgames other than secession. There can be an association by a province with a recognized state. For example, had Kosovo associated with Albania, that would have been an association that would have been acceptable under international law. Reunification of a divided nation is another endgame between East and West Germany, for example. You can have a peaceful breakup, Czechoslovakia's velvet divorce. You can have a constitutional right to independence supplemented by a valid referendum act, which is what Montenegro did when it separated from Serbia. You'll recall the European Community's recognition guidelines that dictate that any change in borders has to be by common agreement. The problem in Crimea is there was no attempt by the separatists to negotiate their local demands to Kiev. And by the time of Crimea's 2014 independence referendum, Russia was actually militarily embedded in Crimea. The separatist movement, in other words, was all too eager to avoid any strategy other than secession from Ukraine. Part 4 of my presentation, Crimea in historical perspective, now that we have the basics of international law behind us. We could arguably start, in a lot of places we could start, even with Kiev Rus, which exercised regional hegemony until Moscow's ascendancy during medieval times. The Tatars held the Crimean Peninsula from the 13th century until the Russian takeover in the 18th century. The city of Sevastopol has been the heart of the Russian Black Sea naval fleet since 1783. The Soviet Union created the Crimean Autonomous Soviet Socialist Republic in 1921. The Crimean SSR was then dissolved in 1945. It was incorporated at that time into the Russian Soviet Socialist Republic until 1954. Stalin then ceded Crimea to the Ukrainian SSR. In 1991, Crimea became the Autonomous Republic of Crimea, but still within Ukraine. And then we take a moment to step back from this time frame to look at the 1994 Budapest Memorandum on Security Assurances in Ukraine. The Budapest Memorandum eschews or is designed to avoid threats against the sovereignty or the territorial integrity of Ukraine. It was signed by Russia. The purpose was to place Ukrainian nuclear weapons under the operational control of Russia. The Budapest Memo specifically provides that Russia, the United States, and the United Kingdom all support the Ukraine becoming a member of the Nuclear Non-Proliferation Treaty. Each of them envision, in other words, immediate UN Security Council action to provide assistance to Ukraine, but only, quote, if Ukraine should become a victim of an act or threat of aggression in which nuclear weapons are used, close quote. Now, the Budapest Memorandum is a political document. It's not really a formal treaty. Neither Bush nor Clinton, for example, neither of their presidential administrations in the United States were prepared to give military commitment to Ukraine. They didn't believe that the US Senate would ratify a treaty on this particular subject. So unlike NATO's paragraph 5 collective intervention guarantee, the Budapest memo did not yield a general military protection for Ukraine. Russia has a good argument at this moment that the Budapest memo does not apply to Crimea. There has been no threatened use of nuclear weapons against Ukraine. That has not happened during the 2014-2015 conflict. On the other hand, if Ukraine acquires a missile defense shield, which it now seeks as of 2 weeks ago, and if Putin follows through on his threat to place nuclear weapons in Crimea, then the question would become whether that insertion of nuclear weapons would violate the Budapest memo because of the implicit threat against Ukraine. So we fast forward from the Budapest memo to November 2013. The prior Ukrainian government had disavowed the Ukrainian Association Agreement with the European Union. That sparked peaceful protests by the people of Ukraine. But that turned violent thanks to the riot police in Ukraine. Early in 2014, there were more protests against the democratically elected president, who was tilting towards Moscow now instead of the European Union, and Viktor Yanukovych was then deposed in a coup d'etat. Yahoo was the first news organization actually to report the then contemporary February 14 meeting of the Russian security service chiefs. At the close of that all-night meeting, Putin reportedly said, quote, "We must start working on returning Crimea to Russia," close quote. All of a sudden, Crimea was the center of pro-Russian demonstrations, ubiquitous appearance of Russian volunteers. And by mid-March of 2014, there was an independence referendum. Soon thereafter, Russia annexed Crimea. Crimea and Sevastopol were almost immediately annexed as Crimea as a special Russian federal district, and Sevastopol as a special Russian federal city. We now move to Part 5, Crimea's secession by way of referendum. Crimea's referendum rules did not state whether there was a threshold minimum number or percentage of votes that would be required for the result to be ratified or to take effect. One could argue that was unnecessary because the result probably was preordained. The Autonomous Republic of Crimea and the city of Sevastopol, which were then discrete subdivisions of Ukraine, suddenly were united as the Republic of Crimea. The new republic claimed to be a sovereign state, and later, shortly thereafter, Russia annexed it. As of March 2014, Crimea was roughly 60% ethnic Russian, 24% Ukrainian, and 10% Tatars. Many Ukrainians, including the Tatar minority, boycotted the referendum. So it's no surprise that the majority of voters, reportedly some 90%, thus voted to join the Russian Federation. And that's very similar to the 2006 Transnistria referendum and its plan of ultimately joining the Russian Federation. And Transnistria may very likely be the reason that former President Saakashvili, Ukraine's Saakashvili, is now the governor of Odessa, which ironically is kind of midway between Transnistria and Crimea. So the Crimean referendum was unconstitutional under Ukrainian law. That's because Article 73 and a 2012 Ukrainian statute both provide that the Ukrainians can have referendums all day long on local matters, but they cannot change international borders. The West's position is that this referendum was invalid, not valid for a variety of reasons, including that the country was effectively, or that the area was effectively under Russian military occupation. The commander of the US Army Europe estimated that there were 29,000 Russian troops in Crimea at the time of the referendum. The European Commission for Democracy Through Law has a sub-entity known as the Venice Commission. It's basically an advisory body to the Council of Europe that was created in 1990 after the fall of the Berlin Wall, when there was an urgent need for constitutional drafting assistance in the former Central and East European SSRs. The Venice Commission declared that the Crimean referendum was illegal, under both Ukrainian and Crimean constitutions, as well as violating international election standards. First, the international expectation is that all citizens of a nation will vote on such existential matters, not just a small portion of it as occurred in Crimea. Second, there were a number of voting irregularities for this particular referendum. Russian state-owned media and referendum organizers claimed that somewhere between 70 and 135 international observers were present to monitor the referendum. They reported that there were no violations, and that itself seems to raise a red flag, because there's usually some kind of violation. For those of you interested in one of the most interesting ones, we have Bush versus Gore, where the US Supreme Court determined who would be the President of the United States. So it's a good thing that we weren't being monitored at the time. But I digress. The de facto Prime Minister of Crimea invited the Organization for Security Cooperation in Europe to observe. The OSCE declined, however, based on the rationale that the Crimean Oblast does not have the authority to invite an international organization to monitor a referendum. That's because Crimea was not a state, and since not a state, it was incapable of requesting the services provided exclusively to OSCE member states. The OSCE chair, Switzerland's Foreign Minister Burkhalter, later declared the referendum unconstitutional. Part 6 of 7. We're getting close to the end. The international reaction to the Crimean annexation. The United States and the European Union threatened and then enacted a number of sanctions against Russia. Both encouraged Russia to withdraw from Crimea. The Visegrad Group, an alliance of Hungary, Czech Republic, Poland, and Slovakia, issued a joint statement which urged Russia to respect the territorial integrity of Ukraine. The members of the Visegrad Group said, and I quote, "are appalled to witness a military intervention in 21st century Europe that is akin to their own experiences in 1956 in Hungary, 1968 in Czechoslovakia, and the 1981 imposition of martial law in Poland," close quote. The Organization for the Economic Cooperation and Development suspended Russia's accession process and instead began to strengthen OECD ties with Ukraine. The Organization of Islamic Cooperation expressed its concern about the security and well-being of Crimea's Muslim Tatars. In 1944, as you know, Stalin, the master of ethnic cleansing, deported a sizable Tatar population to Central Asia, and then he implemented another mass deportation shortly after World War II. So the Organization of Islamic Cooperation said that any recurrence of the past suffering of Crimean Tatars who were expelled from their homeland in the 20th century would not be allowed. Russia obviously ignored the OIC's admonition, because in April of 2015, Russia very recently shut down the last independent TV station which was serving the Crimean Tatars. At the United Nations, 13 of the 15 UN Security Council members voted in favor of a resolution that would have declared the Crimean referendum invalid. The resolution, unfortunately, did not survive the Russian veto. So the Security Council, once again, was rendered impotent by the veto of a permanent member. But on March 27th, 2014, last year, the UN General Assembly debated Resolution 68/262. That resolution called on states and international organizations and their specialized agencies not to recognize any change in the status of Crimea or Sevastopol. All states under this resolution are to desist and refrain from actions that will disrupt the Ukrainian national unity and territorial integrity. The Russian representative's comments were especially poignant. He responded in the debate that an historical injustice has been vindicated. For many years, Crimea had been a part of the Russian Federation, sharing a common history, culture, and people. An arbitrary decision in 1954, in other words, Joseph Stalin, had transferred the region to the Ukrainian Republic, quote, upsetting the natural state of affairs, close quote, and cutting Crimea off from Russia. Under that reasoning, I would love to ask the following question. Mr. Putin, is Alaska next? Less facetiously, as you know, the United States acquired Alaska from Russia some years back. But less facetiously, didn't Russia itself, quote, in the words of the Russian representative, quote, upset the natural state of affairs, close quote, by multiple ethnic cleansing of the Tatars in Crimea, by cutting off Crimea from Ukraine? North Korea, in the debate, attributed the crisis in Ukraine to interference by the United States and other Western countries. Pyongyang claimed that Crimea's reunification with the Russian Federation was conducted legitimately through a referendum in accordance with the UN Charter. Maybe North Korea meant that the UN Charter is similar to the Bible or the Quran, where the same words mean different things to different people. There were a large number of General Assembly abstentions, 58 to be exact. Representative rationales for abstention included the following. China said that all parties should refrain from actions that could exacerbate the situation and should instead work through diplomatic means to resolve the situation. So did China mean that working through the General Assembly is not working through diplomatic means? Nicaragua, for example, said that the Crimean referendum was a peaceful, legitimate exercise of self-determination through the ballot box. Nicaragua rejected, quote, unilateral methods, including the political and economic sanctions against the Russian Federation in violation of international law. Well, Nicaragua has a point in the sense that international sanctions are supposed to be meted out by the Security Council under the Charter's Chapter 7 powers. But as to Nicaragua's language about rejecting unilateral methods, I think Nicaragua may have conveniently ignored that the result in Crimea was the result of a unilateral declaration of independence. So I leave it to this audience to determine the weight that should be accorded to a UN General Assembly vote, given that there were 100 nations in favor of the resolution, which had disavowed Russia's Crimean annexation, and only 11 against. I concede the Article 38D ICJ statute list of sources does not include General Assembly resolutions, but that too is an issue which I'd love to discuss, but is beyond the scope of today's presentation. This brings us to the final part of my presentation, the conclusion, another frozen conflict. The so-called elephant in the room is the post-Cold War splintering of states beyond the Soviet Union and the former Yugoslavia. One result is the numerous unresolved conflicts that we have seen and will continue to see that defy a resolution that's acceptable to all. Only Tunisia, for example, seems to have benefited from the Arab Spring. Chaos is everywhere in other parts of Africa and the Middle East. The ISIS caliphate is just getting started. It has temporarily splintered Iraq and Syria. The 6 provincial genies that are in Russia's backyard, South Ossetia, Abkhazia, Nagorno-Karabakh, Kosovo, Crimea, Transnistria, are not likely to be squeezed back into their prior geopolitical bottles. Realpolitik, I think, counsels against the likelihood of any near-term resolution of those conflicts or the validity of those successions. The UN Security Council, because of the veto, is unable to implement its role to try to control those threats to peace. So, where are we? I've explored the legal features of the Crimean annexation under international law, but the political reality is this. What would be gained by forcing the people of Crimea back into Ukraine, if that were possible? So for now, Crimea is yet another frozen conflict that's not likely to resolve in my lifetime or yours. One could characterize the vast majority of these modern secessions as examples of international proxy wars, whereby what I call Cold War light is now brewing. And when I say light, I'm analogizing light beer as in Budweiser light. Russia has now challenged the Cold War order that prevailed for some years after World War II. Russia has recently withdrawn from consultations that are required under the 1990 Conventional Forces in Europe Treaty. And under the 2015 Minsk Agreement, Russia was supposed to withdraw troops and weapons from Ukraine, But there are, of course, now reports that you're all reading in the newspapers every day that Russia is doing just the opposite, pouring troops into Ukraine, 29,000 in Crimea during the referendum last year. And as of just last week, within the last 7 days, Russia joined the European Union in tit-for-tat individual travel bans against selected politicians from the European Union. The U.S. is now considering an Eastern European missile defense system again. In April 15, just this last month, the U.S. sent 300 military advisors to Ukraine. That's how things started in Vietnam. Putin has already threatened to put nuclear weapons in Crimea. And I don't think President Obama is going to declare another so-called red line that would supposedly trigger a U.S. retaliation. So, power politics has frozen these conflicted areas like Crimea into geopolitical twilight zones. The result is that they will remain economically stagnant, subject to military occupation. They'll continue to serve as proxy wars for years to come. And in the final analysis, these secessionist oblasts are pawns in an international chess match between two kings. They say it's hard to predict, especially when it's about the future. But it's not hard to predict that if Ukraine gets a missile defense shield and President Putin counters that by actually placing Russian nuclear weapons in Crimea, we can remove the word light from the phrase Cold War light. Because then you, me, and our children will bear witness to the already evolving Cold War Round 2. Thank you for your courteous attention. It's been an honor to address Debreceni University and soon Catholic University and the Hungarian branch of the International Law Association. It's my hope that the leaders in these various institutions and the future leaders sitting around this table today will continue to shine your academic light on the decision makers who will hopefully live up to the adage that with great power comes great responsibility. Thank you.